Right. Now, our next topic is winding up. Right. I think last time we have discussed about the modes of winding up. Now, consider the winding up. Right, I told you this is the end of the conference. So after winding up, after liquidation, the existence of the company is seen. Thereafter, there is no such conference, right? Now, basically, we can identify some steps to be taken in order to liquidate the company. The first step is company has to collect all its assets. Right? That's the first step. Collecting the assets of the company. Then second step is realize the assets. Right? Then the third step is by using the proceeds, company has to pay for the creditors, right? Creditor and winding up expenses. And after paying creditors and winding up expenses, if any amount remains in the company, right? It is seen as surplus effects. It could be distributed among the shareholders, right? Collecting the assets. First step, collecting the assets. Right, realize them. Realize the assets. Right, and pay creditors. Right, creditors. Then winding up expenses. Right, creditors and winding up expenses we can mention together. Creditors and winding up expenses. Then after paying the creditors and expenses, if any amount remains in the company, it is named as surplus assets. Right, surplus assets. It could be distributed among the shareholders. Right? It could be given to the shareholders. That is the end of the company. Right, or existence is ceased after the liquidation, after this process. Right, that is the winding. Right now, when we consider the modes of winding up, I think I have little bit explained, right? We can identify there are three modes, right? Company can be winding up by three ways, three means, right? First one is by court. This is named as compulsory winding up. Another name given to the winding up by court, compulsory winding up, right? Another name. Compulsory winding up. another name by court, right? Then the second mode we can recognize voluntary, right? With consent of the shareholders, they can liquidate the company. With consent, voluntarily they can liquidate the company. I think you can, right, understand voluntarily. Now, suppose the shareholders, they are going to liquidate the company with their consent. So here, shareholders must pass a resolution, like a general meeting. Like this type of resolution to be passed in order to liquidate the company. At a meeting, this type of resolution to be passed. Right? Yes. And the resolutions we have discussed. Yes. Now, when we consider the meetings, general meeting is shareholders meeting, right? AGM or EGM, like that. AGM, like annual general meeting, shareholder general meeting. At a general meeting, by passing a resolution, shareholders can make decisions. This decision is liquidate the company. With consent of the shareholders, they can make a decision to liquidate the company. Wind up the company. So in order to make this decision, this type of resolution to be passed. This type of resolution. What are the resolutions can be passed at a meeting? Yes. There are basically two types of resolutions can be passed. Ordinary and special. Special. Right. So ordinary resolution means it is a resolution which is passed by simple majority of votes. I told you more than 50%. Right? More than 50. That is simple majority. Right? Simple majority of votes. And the special resolution, right? This is a resolution which is passed by majority of 75% of votes. Thus, not less than 15 working days notice to be given. After giving not less than 15 working days notice, right? Meeting called, right? Then at the meeting, by majority of 75% of votes, that resolution is passed. That is saying as special resolution. Now tell me which type of resolution to be passed, ordinary or special? Not to liquidate the company voluntary. Tell me this is whether liquidation of a company is a serious matter or minor matter. Very serious. There are companies no, right? Not available. That is the end of the company. Right? Now I told you, in order to overturn the articles. Articles means articles of association. This is the constitution of the company. Basic law, constitution of the company. In order to amend the articles, special resolution requires. In order to approve major transaction, special resolution requires. Right? In order to change the name, special resolution requires. Right? In order to approve the amalgamation with another company, merge. Right? Company is going to merge with another company, amalgamation. Then special resolution requires. The seriousness, we have to consider the seriousness of the decision. So here also very serious. Right? There is like terminating the existence of the company, right? With consent of the shareholders. Very serious matter. Therefore, by passing a special resolution, right? Special resolution. Right? Shareholders can voluntarily liquidate the company. Understood? Right. So voluntary winding. And the third mode is actually this is a subcategory of the voluntary winding now. We name it as subject to supervision of the court. Right? Subject to supervision of the court. Subject to supervision of the court. That is the third mode. Actually, now here, very simple thing. That is, suppose special resolution, right? Special resolution pass in order to liquidate the company voluntarily. Right? Decision is right taken by the shareholders to liquidate the company voluntarily. Then what happens? Right? A shareholder who has voted against the resolution, suppose, who has voted against the resolution, shareholder, right? Or creditor of the company can make an application to court to liquidate it voluntarily, but subject to supervision of the court, right? Liquidate the company voluntarily, but subject to supervision of the court. And court will supervise the liquidation of the company. Supervise the steps of the liquidation, right? That is named as subject to supervision of the court. Right? I think this is a subcategory of the voluntary wrongdoing. Right? Special resolution passes to liquidate the company voluntarily, shareholder, right? Or a creditor can make an application to court, right? To liquidate it subject to supervision of the court. The court can accept that. Under supervision of the court, company will be liquidated. That is the third point. Now, actually, out of these three modes, very important one is court by court. Right? Now, when we consider winding up by court, right? Winding up by court. Winding up by court. Right? So we can identify some grounds, right? Some grounds for winding up by court, right? Right. So these grounds are very important, right? Basically, right, there are several grounds, right? But basically, we can identify, right, two grounds, right? Two grounds that the company can make an application to court to liquidate it by court. First one is very important ground is the most important one. That company unable to pay its debts. Unable to pay its debts. Make හැමදාම විභාගය අහනවා. Unable to pay its debts. Then actually not only the company, director, shareholder, creditor, right? Or the register of companies can make an application to court to liquidate the company by court. There are several persons recognized, right? It is not confined to shareholders, right? Creditors can make an application. Creditors, like shareholders. But in this topic, actually, instead of shareholders, we name shareholders, name. Instead of this word, we give another technical term that is contributors, right? Contributors. Right? Instead of shareholders, we can name contributors. Contributors means the persons who are contribute to the assets of the company in the event of liquidity. Because now, when we consider the types of companies, right? We can identify in some companies, they have share capital, right? Share capital, private company, unlimited company, public company, right? So these companies, they have share capital. Therefore, we can identify share capital, shareholders, right? If there is a share capital, we can identify shareholders. So shareholders. There is a share capital, then we can identify shareholders. But when we consider the companies limited by guarantee, right? They don't have share capital. Therefore, we name the owners as members, right? We are shareholders instead of shareholders in a company limited by guarantee. We name them as members. Therefore, actually, shareholders or members. Members. And members under articles of association, members of the company, right? They have undertaken to contribute to the assets of the company in the event of liquidation. Right? If it is a company limited by guarantee, whatever they have to carry out of you. So that is the right way. So the members. So shareholders and members all together we can name as contributors. So who can make an application to liquidate the company by court? Contributors. You can say contributors, right? Creditors, right? And directors. Director can make an application. And registrar companies are also registrar company, right? Can make an application to liquidate the company by court. They can make an application. So here, one ground for such application, that is unable to pay its debts. Company unable to pay its debts. Right? Now here we can identify some examples given in the Companies Act, which indicates that the company unable to pay its debts. Right? One is basically we can identify there are two instances given in the Companies Act. Right? That is the first one, we can number as 1 and 2, right? First one is the company, this is the company owes to a creditor, right? Company and creditor, right? Company and creditor, right? Company owes to a creditor, right? More than 50,000 rupees. 50,000 rupees. So actually there are three conditions to be satisfied. Right? Company owes to a creditor more than 50,000 rupees. Then thereafter, right, this creditor, right, creditor has requested the money in writing, right, written demand made by the creditor. Written demand. Right? Creditor is writing demanded the money. Right? Right? Written demand. Right? Then what happens? Right? Within 3 weeks' time, 3 weeks, within 3 weeks' time, this company unable to settle the money in full, or neglect to settle the money, or unable or neglect to settle the money in full. Right? Then it deemed that the company is unable to pay its debts. Very important, right? Always now actually the questions are right related with this unable to pay its debts. Right? Creditor and company. Right? Company owes more than 50,000. Amount is very important. 50,000 rupees, right? 500,000. 50,000, very small amount. 50,000 rupees, more than 50,000 rupees. Then creditor in writing, right? He has demanded the money, but within 3 weeks' time, company unable to settle the money. Then actually being that the company unable to pay its debts, then creditor can application to court to liquidate the company by court. I told you, right? Who can make an application to court? Creditor, shareholder, register companies, right? Anyone can. Right. So, yes. So we deem that the company unable to pay its case. So that creditor can make an application to court to liquidate the company by court. Why is the main ground of creditor? Here the company neglect to pay money, right? Unable to settle the money. Then what is the next step in order to recover the money? What is the step? That is, creditor make an application to court to liquidate the company. Under liquidation process, creditor can recover money. Creditor can recover this money. Right? Yes. How it can be recovered? Now here, this creditor can make an application for thereafter under winding up process, right? Company has to collect the assets, realize them, thereafter out of the proceeds, company has to settle the creditors. So by that way, creditor can recover the amount. This is main objective. If the company is not settle the money, right? If the company is not settling the money by disposing the assets of the company, the liquidation process by disposing the assets of the company, he can recover the money, right? Then actually court will intervene to liquidate the company. This is liquidation by court. Court will intervene to liquidate the company. Then court can, right? After disposing the assets, settle the creditors, right? And if there are, I told you, winding up expenses, then if any amount remains, distributed among the shareholders. So by that way, creditor can recover the money. So with that objective, we can make an application to court to liquidate the company by court. Understood? Right. So this is the one incident for unable to pay its debts, right? 50,000 rupees written demand, right, from the creditor, and within 3 weeks' time, company unable to settle it, right? So it being that done, company unable to pay its debts. And there's another example, that is execution order. Execution order, return unsatisfied. In full or part. In full or part. Execution. Right. Execution order, return unsatisfied in full or part. Now, very simple concept. This order is named as execution order. Order, right? Execution order. Right? Execution order. Execution order means, now suppose, now creditor, this is the company, and the creditor. No, not creditor. First we can consider company and X, another party, company and X. They engage into a contract, right? A particular contract. Then after engaging into this contract, suppose the company has breached the contract, breached the contract. Right. Then, as the innocent party, X file an action against the company in order to recover damages, right? Damages. As the innocent party, actually, right? X is entitled to recover damages on the basis of breach of contract, right? So, on that ground, he filed an action against the company in order to recover damages, right? Then, after considering the evidence, right? Then court right. After considering the evidence, court has given final decision. It is named as judgment. Right. Judgment. Judgment. It is the final decision of the court. Right. After considering evidence, court has given a judgment. Right. Judgment in favor of X. Right. Innocent party or aggrieved party. Right. So according to the judgment, suppose company has to pay 100,000 rupees to X. Right? Company has to pay 100,000 rupees to X. So after the judgment, we can identify this X. Right? He plays to, right, as a creditor. Actually, here we name X as after judgment. X is named as judgment creditor. Judgment creditor. And the company is treated as judgment debtor. Again, now we can identify debtor and creditor relationship here. Because according to the judgment, company has to pay money to X. Therefore, X has the position as a creditor. Therefore, we name it as judgment creditor. Judgment debtor. That's debtor and creditor relationship period, right after the judgment. Now, creditor can recover money from the debtor. Right. So even after the judgment is given, suppose company unable to pay this amount, 100,000 rupees. Then how creditor can recover this amount? Right? That is, one way is, right, we need to make an application to liquidate the contract. Right? Right? We need not to make an application to liquidate the contract, right? Before that, right, suppose another option given to the judgment creditor, right, we can execute the judgment against the judgment given. Right? That is same as execution. Execution. Then he will ask the court to issue an order to execute this decision. Then that order is named as, right, execution order. Execution order. Execution order. This order issued by the court, right, in favor of the judgment creditor is named as execution order. Actually, under this execution order, right, creditor can seize the assets of the company. Seize the assets. Very simple method, right? We can identify in courts some officers, right? Fiscal. One officer is named as fiscal. So, fiscal officer, right? By this order, court authorized the fiscal officer to seize the assets. right? Seize the assets and sell them in the public auction, right? Public auction, sell them in the public auction and recover the money, right? Recover the money, right? So this order is named as execution order. This is an order of the court to seize the assets and sell them in the public auction and recover the amount due to the judgment creditor. So this order is named as execution order, right? So this is the way how judgment creditor can recover money. It's a simple, right? An individual party also say, right? Suppose there is a, right? Instead of company, there's another person, right? Individual person, then judgment creditor can make an application to court for execution order. If the execution order is due, then with the discharge, he can go to that place and seize the properties. Then we can sell them in the public auction. I'm not being movable or immovable property, seize. Right? Seize the assets of the debtor, sell them in the public auction and recover the amount. Right? Both are like they have to be my gun among the number of people, so nothing to seize. My gun, you know, I never so I'm able to execute that. There's no sufficient assets. The So I'm able to execute this execution order. Those I have no sufficient assets to meet the execution order. So that method, like same concept here. Like execution order, return unsatisfied in full or part. It means actually that this company doesn't have enough property to meet the execution order. No assets. That is the right. That is the reason for returning. Right. Execution order return unsatisfied. Right. In full or part. Right. It deemed that the company unable to pay its debts. This is the second ground. Right. So execution order return means, right, the company doesn't have sufficient assets, right? Execution order return. Return means, the meaning is, company doesn't have enough assets, no assets. Execution order return, unsatisfied, unable to recover the money, right? Unable to recover the money in fully or part of the money, unable to recover. It means actually the company, right, doesn't have enough assets, no assets in the company. That's why this execution order is return. Return means ක්‍රියාත්මක කරන්න බෑ. අනුන්ගේ මිනිස්සු ෆෝන් දේපල වෙනාට පවරලා දුන්නාට පස්සේ කතා කරන්න දෙයක් නැහැ. There's no sufficient asset to meet the execution order. So again, we can say the company deemed that the company unable to pay its debts. These are the main two grounds for, right, unable to pay its debts. Company unable to pay its debts. Right. So these are the right. Yes. Instances mentioned in the Companies Act. Right. Right. Then this is under unable to pay its debts. Right. Then unable to pay its debts. Right. The first one is this one. Right. 50,000 rupees written demand. 3 weeks time unable to pay it. Then execution order, right, return unsatisfied in fully or part. Right? Again, we can say the company unable to pay. That's why execution order is written. Then another ground for making an application to court for liquidation, actually court can decide that, right? That is, if the company is a bubble, it is just, right, just incorporated, but it never had any business, no any business or any asset, no any asset. Then it's a bubble. Then court can decide, right? Liquidation is reasonable, right? That is according to the opinion of the court. Court can decide whether the liquidation is reasonable or not. It is a bubble company, right? That is no any business after incorporation, no any business, and no any asset owned by the company. Then it's a bubble, right? Then court can decide, right? The liquidation is just and reasonable, right? So the second ground for winding up by court, right? Court is of the opinion, court. Winding up is just and reasonable. Winding up is just and reasonable. Right? If it is a bubble and after incorporation, it has never, right, do any business activity, right, within 1 year or suspended its business for 1 year. There are several reasons, some other reasons also we can consider. Only thing is, according to the court's opinion, liquidation is just and reasonable. But then can make an application to court to liquidate the company by court, right? So these are the grounds for compulsory winding up or winding up by court, right? Right. Right. So these are the basic things with regard to the winding up by court. Then thereafter, we consider about the steps in winding up by court, right? But when we go through the notes and all that, actually we are unable to identify what are the steps. It's not clear, right? It's not clear. But so very simple steps to be taken, right? Under the winding up by, we can discuss about what are the steps, right? What are the steps we can identify, and all the steps I will explain by this, right? The simple diagram, right? I will explain that, right? Now, we have discussed, right? Credit, right? These are the steps, right? And the winding up by court, right? Credit, register of components, right? Or contributaries, they can make an application to liquidate the company by court, right? Then, how they can make an application to court, right? They have to file a petition, right? Now, suppose this is the time. This is the time, right? Right. So this is the date of filing of the petition. First, they have to, right, the shareholder, right, register this or whatever. The person who is seeking the liquidation of the company must make an application by way of a petition. Right? Petition. Right. Now I told you company and X engage into a contract. Then I told you the company has breached the contract. Right? Then X file an action against A in order to recover damages. Damages. Now, in this case, right, in order to recover damages from the company, in this case, X, right, this party, other party to the contract, or the innocent party, or the aggrieved party, he must file an action against the company, right, by way of a plaint. Here, X has to file a plaint, not a petition. Plaint and petition, two different processes, but same actually, right? This is the request to recover the money, right? In the court, right? X is going to recover the money. So here also same, through the court, this party is going to liquidate the company, but by way of petition. In a petition, there is special feature is, right? Along with the petition, you have to file an affidavit. Plus affidavit. Petition plus affidavit. Right? So there is the procedure. Right? Petition along with an affidavit. Affidavit means there is the evidence given by the petitioner. Evidence. So without having evidence, right, court cannot make any order. Court cannot make any order without having evidence. First, court has to consider the evidence. Thereafter, court can make suitable order. So without having evidence, court cannot make any order. Right? But here what happened? Now, along with the petition, the petitioner must file an affidavit. The court can make suitable orders. Right? Suitable order. We consider what are the orders going by the court once the petition is filed. But here actually cannot make only plaint file. Then thereafter, company has to file an answer. Plaint and answer. Then after that, matter is fixed for trial. A long procedure. It will take long time. Then trial. At the trial stage, parties can leave the evidence. Then after considering the evidence, at the trial, leave the evidence. And then so after considering the evidence, then thereafter court will give the final decision. At the trial stage. Right? So therefore, right, in the first instance, court cannot make suitable orders without having the proper evidence. Right? So that is the in general matter, right? In order to record evidence like this, but here, here petition along with an affidavit. Petition along with an affidavit means, abhi diurum prakashite ahari hone. Diurum prakashite indene sakshi apane. And you got a petition along with an affidavit. Right. Abhi edoda over tamai venasa hai. Right. Time karega. Right. So you have to file a petition along with an affidavit. Right. That is the requirement. Right. Then thereafter, after petition is filed, then now the evidence is also given to the petition. Right. Then thereafter, court will appoint an officer of the court. An officer of the court. This officer is named as official receiver. What is the name? Official receiver. Official receiver. He is an officer of the court. An officer of the court. Therefore, an independent person. Independent person is appointed as an official receiver. Court will appoint an independent party. Why? Now, the application is made in order to liquidate the company. Then after making such application, allowing the directors and shareholders to control the affairs of the company, it's a risk. Therefore, in order to displace the directors and shareholders' powers, this independent party is appointed. So this party, an independent party, an officer of the court, appointed as an official receiver. This person is, this position is named as official receiver. Nila bara ganun karugil apiyahan. Official receiver. Is appointed by the court. Right, so this is the next step. Or no, right? Or no, after the filing of the petition, right, to liquidate the company, court will appoint an official receiver. Right. Then this official receiver, right? Official receiver by virtue of his office. Official receiver by virtue of his office, right? Be appointed as provisional liquidator. Right? Another party, provisional liquidator. Provisional liquidator. Provisional liquidator. Right? Official receiver by virtue of his office. Right? What is the meaning of that? By being the official receiver, right? This person, right? Same person be appointed as the provisional liquidator. That is the meaning. An official receiver is appointed by virtue of his office. Right? Official receiver will be appointed as the provisional liquidator. Right? The court has to appoint only the official receiver. The same party will be appointed as the provisional liquidator. Now, when we consider another situation like this, President of Sri Lanka, by virtue of his office, will be the commander for the three forces. Right? Separate person, separately we need not to appoint. Right? President as the commander for three forces. Only thing is, by appointing the President of Sri Lanka, by virtue of his office, he will be appointed as the commander for three forces. Dure name, dure dharana, dure name, make it up. By virtue of his office. They can have everything. They have help. Official receiver is appointed. Then, by virtue of his office, right, official receiver will be appointed as the provisional liquidator. Provisional liquidator. Same party will be appointed as the provisional liquidator. By provisional liquidator, he will conduct the affairs of the company for a short period. For a short period. Short period means until the winding up order is given. The only petition is filed. The court has to consider the evidence. Then thereafter, court has to give an order, binding up order. So until the binding up order is given, right? In order to monitor the affairs of the company, provisional liquidator is appointed. Provisional liquidator is appointed. Right? So that is the next officer, that next position that we can identify under this winding. official receiver. Then, by virtue of his office, official receiver will be appointed as the provisional. Right. Provisional liquidator. Then thereafter, after considering the evidence given by the parties, court will, right, make a binding up order. Binding up order. Binding up order is given. After considering the evidence, court can dismiss the matter or binding up order can be done. Right? Two things may happen. Right? Now, supposing here, binding up order is given by the court after considering the evidence. Right? Then, after the binding up order, court will appoint, right? Court will appoint another officer. After the binding up order, court will appoint another officer. This officer is named as liquidator. Earlier, provisional liquidator. He is named as provisional liquidator. That is for a short period. He will, right? He will appoint to monitor the affairs of the company. That is until the binding up order is given. In simple terms, until the binding up order is given, in order to monitor the affairs of the company, right, provisional liquidator is appointed. So after the binding up order is given, then court will appoint the liquidator. Right? So this person is named as liquidator. Liquidator. Right? Liquidator. Right. So three officers we can identify. Official receiver. Same person will be appointed as the provisional liquidator. That is for short period. Or we can say until the binding up order is given, in order to monitor the affairs of the company, provisional liquidator is appointed. Then after the binding up order is given, then court will appoint liquidator. The liquidator will conduct the liquidation process. That is collecting the assets, realize them, right, settle the creditors, winding up expenses, and surplus assets, right, distributed among the shareholders. So winding up, right, proceedings will conduct by the liquidator. Right. So three parties we can identify: official receiver, provisional liquidator, right? Same party will be appointed as the provisional liquidator. And finally, after the winding up order, that is after the winding up order, after the winding up order, liquidator is appointed. They will conduct the liquidative proceedings. Liquidate. Right. So this is the procedure. Right. This is the procedure of winding up by court. Right. Then another very important concept we have to consider, that is, right, the effective date of winding up order. Right? Effective date. Effective date of winding up order. Right. Now suppose the petition filed on 1st of January. Right? Winding up order, after considering the evidence, winding up order is given on 31st of March. Right. So what is the effective date of this winding up? That is very important, right? Right. Remember, right? Effective date of winding up order is the date on which filing of the petition, right? That is 1st of January, right? Winding up order is valid from the beginning of 1st of January. From the date petition is filed, winding up order is valid, right? Therefore, effective date is 1st of January. 1st of January. It is very important, right? Reason is, during this period, right after filing the petition and until the winding up order is given, during this period, if any, right, transfer of any property of the company, transfer of any property, disposition, or alteration made to the rights of the shareholders, all the transactions to be treated as void transaction. Void. Right? Therefore, the effective date of winding up order becomes very important. So, after filing the petition, all the transactions or disposition of any property become, right? Any transfer of property to another party, or alteration made to the position of the shareholders, all the transactions to be treated as void. Void means no value, null and void, no any value. Right. So that is because of the effective date is treated as the date of filing of the petition. Not from here, from the beginning, winding up order, right, becomes effective. Otherwise, once the petition file did not liquidate the company by the creditors, the company can transfer the assets of the company to another person. Right? After the winding up order, nothing was return the amount. Right? Under the winding up order, collect the assets, realize them, and settle the creditors. How company can continue the proceedings, unable to proceed. Therefore, effective date of the winding up order is treated as the date of filing of the petition. From the beginning, then until the winding up order, during this period, all the transactions are treated as void. All the transactions. So this is the next point, right? So, petition filed along with an affidavit, then after some time winding up order is given, then effective date is treated as the date of filing of the petition. Therefore, during this period, all the transactions are treated as void. When the official receiver appointed, after the petition file, then by virtue of his office, official receiver will be appointed as the provisional liquidator until the winding up order, in order to monitor the affairs of the company until the winding up order is given. Then after the winding up order is given, the court will appoint a liquidator. One or more liquidators can be appointed in order to conduct the winding up proceedings. Right? So that is the way. Right. Then, is it clear? Then, when we consider the official receiver, he has two duties. Official receiver. Official receiver. Duties. Right? He has two duties. Official receiver has two duties. The first one is he must obtain a statement. It is named as statement of affairs. statement of affairs. Right? Statement of affairs. Right? We must obtain a statement of affairs from the secretary or the directors or in person. Statement of affairs. Statement. So this statement is named as statement of affairs. Actually, this statement is it's like a actually in this statement we have to mention the particulars mentioned in the balance sheet. What are the assets? Right? In this statement, assets owned by the company, they have to declare what are the assets. Assets and liabilities. Yeah, they only in the balance sheet. Assets and liabilities. And names and addresses of the creditors. Names and addresses of the creditors. Name and addresses of the creditors. And what are the securities given to these creditors? Right? Securities held by the creditors. Securities. So, stating these informations, right? Stating these information, he must obtain a statement from the board of directors, right, or the secretary, or any person named by the official receiver. He must obtain this statement. Right? So these are the details in the statement. Assets, what are the assets, liabilities, names and addresses of the creditors, right? Creditors, and the securities held by the creditors, right? So statement of affairs, right? Then the second duty is he must hold 2 separate meetings of right. He must, this is the second duty. He must call 2 separate meetings of creditors and contributors. Right? 2 meetings. 2 meetings of right? 2 separate meetings of creditors and contributors. Right. Who are the contributors? Shareholders or members. Right? Shareholders and members. Shareholders or members. Right. If they have share capital, then shareholders, contributors. If it is a company limited by Galle, then members, contributor. 2 means 4. That is another duty cast on the official receiver. Right? He must obtain statement of affairs. Right? That is like a balance sheet. The plus mentioned in the balance sheet to be given in the statement. And 2 separate meetings, right? 2 separate meetings of creditors and contributors, right? Why these 2 meetings called? In order to decide 2 things. Very simple, right? In order to decide 2 things. One is whom to be appointed as the liquidator. After the winding up order, after the winding up order, liquidator is appointed. Then, in order to decide, he or another person to be appointed as a liquidator. So, in order to decide that, whom to be appointed as a liquidator, right? In order to decide that, he must call 2 separate meetings. In order to decide, right, whom to be appointed as the liquidator. liquidator. That is after the winding up order. After the winding up order, whom to be appointed as the liquidator. Now, official receiver is the provisional liquidator until the winding up order is given. He will conduct the right affairs. He will monitor the affairs of the company until the winding up order is given. Then after the winding up order, I told you, court will appoint liquidator. So in order to decide whom to be appointed, he or another person to be appointed as the liquidator, he must hold two separate meetings of creditors and contributors. That is one reason for the two separate meetings. And the second one is, in order to decide the committee, there's a committee appointed, right? After the binding up order, actually, committee appointed. This committee is named as Committee of Inspection. Committee of Inspection. It's a committee, right? Actually, committee means it is consists of small number of contributors and creditors, right? It is consists of yes. This is consists of small number of creditors and contributors, right? So in order to appoint the committee of inspection, he must hold separate two meetings. It's a committee. Committee appointed, right? Consists of small number of creditors and contributors. Actually, this committee main duty to assist the liquidator to certify in the accounts of the company. Certify the accounts of the company. For that purpose, this committee is appointed. Right? They will assist the liquidator to certify the accounts of the company. For that purpose, right, a committee is appointed. This committee is named as Committee of Inspection. This is consists of small number of shareholders and board parts. So, in order to appoint the Committee of Inspection, two separate details to be called by the receiver. That's all. That's it. This is the procedure under liquidation by force. So compulsory winding up. And උච්චරයි තියෙන දැනගන්න. හරිද? ඕන ප්‍රශ්නයකට ලියන්න පුළුවන්. හරි. Contributor is this one. This consists of small number of creditors, 2 3 creditors and 2 3 contributors. Right? This is formed by these. Who are the members of this committee? Creditors and contributors. So, committee appointed in order to certify the accounts of the. Actually, they assist the liquidator to certify the. That is their main duty of the committee. And then another. Accounts. Give certifying it. You know how to come and get on. This is Right. Take attendance. Right. We'll consider this. Right. This is regarding to the winding up by court. What is named as compulsory winding up. And now, in order to liquidate the company by court, first step is filing a petition. Right. Actually, there are several parties recognized. We can make an application to court to liquidate the company by court, like shareholders, creditors, registrar of companies, like contributors, like they can make an application. But here the very special feature is petition along with an affidavit to be filed. Affidavit means that is the evidence given by the petition. But then thereafter, court can make some decisions. Right. So after filing the petition, court can appoint an independent party, right, as official receiver. Actually, official receiver is an officer attached to the court officer, appointed as the official receiver. Then what happens? The same person will be appointed as the provisional liquidator. Provisional liquidator. By virtue of his office, official receiver, he appointed as the provisional liquidator. Right? Provisional liquidator means, right, he will monitor the affairs of the company until the winding up order is given. Therefore, for a short period, this party is appointed. Provisional liquidator. To monitor the affairs of the company. Short period. Right? That is short period means until the winding up order is given. Right? The provisional liquidator will monitor the affairs of the company. Then thereafter, winding up order is given. Right. After the winding up order, right, we have to consider what is the effective date of winding up order. Effective date is, right, date of filing of the petition. Therefore, from the BSAA, right, until the winding up order, during that period, any transaction, right, in relation to assets or position of the shareholders to be treated as void. To be treated as one. Right? Then thereafter, after the winding, always after the winding up order, liquidator is appointed. Liquidator is appointed. Right? Then thereafter, we have discussed there are two main duties of the official receiver. He must obtain statement of affairs. These are actually the assets, like liabilities, what are the assets, liabilities, and the main analysis of the directors and the securities held by them. So, by including this information, the statement to be given to the official receiver. Then, the second duty is call two separate meetings of creditors, and one is with creditors, right, and the second meeting with contributors, right. The reason is, right, in order to decide whom to be appointed as a liquidator. So after the winding up for the liquidator to be appointed, therefore, in order to decide whom to be appointed as a liquidator, we or another, generally in practice, the same party will be appointed as the liquidator. Official receiver appointed as the provisional liquidator. Generally, same person will be appointed as the liquidator. And in order to conduct the liquidating process, same person will be appointed. Now, in order to decide whom to be appointed, we or another person to be appointed as a liquidator, two details to be called. And the second reason is in order to decide, right? In order to decide how to appoint the committee of inspection. Right? Committee of inspection is a committee assist the liquidator, to certify the accounts of the company. That is their main committee, right? The committee of inspection, right? So, in order to decide these two things, the official receiver has to conduct two separate meetings. Yes, continue. So then thereafter, after the decisions, right, made at the two separate meetings, court will consider the decisions, right, made at the two separate meetings, then accordingly, suitable person will be appointed as the liquidator. The liquidator, this party, right, will conduct the liquidating process, that is collecting assets, realize them, and settle the creditors and settle the winding up expenses, and thereafter surplus assets to be distributed among the shareholders. Right? Surplus assets to be distributed among the shareholders. So that is the winding up proceedings, right? With conduct by the liquidator. Understood? Yeah. Why official receiver is appointed? But the reason, an independent party appointed by, yes, right, in order to display the powers of the directors and shareholders, because allowing them to, right, allowing them to control the affairs of the company, it may be harmful to the creditors. Therefore, in order to secure the payback to the creditors, an independent party is appointed in order to monitor the affairs of the company until the binding of order is thereafter liquidator will place to that position. He will conduct the right binding of proceedings. So that is the reason. Because he is an officer attached to the court, therefore an independent party. Right? Independent party. He will conduct the, he will be appointed as the professional liquidator. Most of the occasions, same party will be appointed as the. So that is the end of the answer. Again, actually, this is the way how we can remember steps. We are considering the note is very difficult to understand. Right? All our paragraph wise, they are mentioned, right? But I think this is the easiest way. Right? Only 3 parties involved in the winding up by court. Right? Official receiver. Same party will be appointed as the provisional liquidator. Then after the binding of order is given, liquidator will be 3 parties. After the always after the binding of order. After 31st of March, binding of order, liquidator will be appointed. In order to conduct the liquidating proceedings. And there is his date. Right. Provisional liquidator, he will conduct the, he will monitor the affairs of the company until the winding up order is given. Provisional liquidator. Therefore, he will be appointed for short period. Appointed for short period. Short period means until the winding up order is given. Therefore, we name that party as provisional liquidator. For a short period, he will be appointed. Then after the winding up order, liquidator. That party is named as liquidator. Provisional liquidator for a short period until the winding up order. After the winding up order is given, liquidator will be. Is it clear? මේක තමයි පිළිතුරේ උදේ දාගෙන නෝ. See, here you can also put this prescription. Within that, it's a procedure of binding up by code. Shall we ask this first class? Uploaded to earlier next time. An application to wind up a company by the code shall be made by way of by way of what is the answer? Question number one, by way of a petition. A petition along with supporting the tax by an affidavit. Number two, affidavit. Right? Petition and affidavit, right? Then after the application is made for winding up by the court, the court will appoint, right, that he or she is an officer attached to the court by virtue of his office, right? He may be appointed as the right, number three, after the application is made for winding up by the court will appoint an official receipt, right? Number three, official receipt, right? He or she is an officer attached to the court, and by virtue of his office, right, he may be appointed as the number four, provisional liquidator. Provisional liquidator of the company until the winding up order is given by the court. Right? That is until the winding up order is given, provisional liquidator is appointed. Then after the winding up order, the court may appoint, after the winding up order, who is appointed? Liquidator. A liquidator to conduct the winding up process. Right? That is collecting assets, realizing, settling the creditors and expenses, right? Winding up process. If not, right? If not, will act as the to conduct the winding up process. If not, here actually number 6. If the liquidator is not appointed, then who will act as the yes, if not, will act as the number 7 should be liquidation. Act as the liquidator to conduct the winding up process. Number 7. So if the liquidator is not appointed, who will act as the liquidator? Provisional liquidator. Official receiver, we can say official receiver. Number 6, official receiver. If not, official receiver will act as the liquidator. Number 7, liquidator. Conduct the winding up process. I told you same person, generally same person will be appointed as the liquidator. Right? So actually separate person is not appointed as the liquidator, provisional liquidator. So we can say official receiver, right, will act as the liquidator to conduct the winding up process. Right? The commencement date of the winding up by court is the date of filing the petition. Number 8, petition. After commencement of winding up, any sale, disposition, or transfer of any property to be treated as void. Like no value. The duty of the committee of inspection is to inspect and certify the land of the company, accounts of the company. And an application to wind up a company by the court shall be made by way of a petition along with supporting facts by an affidavit. Number 2, affidavit. After the application is made for winding up by the court will appoint an official receiver. Right? Number 3, official receiver. He is an officer attached to the court. Right? And by virtue of his office, he may be appointed as the provisional liquidator of the company until the winding up order is given by the court. After the winding up order, the court may appoint, right, liquidator. After the winding up order, always liquidator to conduct the winding up process. If the winding up process will be conducted by the liquidator. Then thereafter it says the commencement winding up process. If not, official receiver will act as the liquidator to conduct the winding up process. If not, official receiver, or we can say provisional liquidator, same partner. Official receiver by virtue of his office, he appointed as the liquidator, provisional liquidator. Provisional liquidator will act as the liquidator to conduct the winding up process. Then commencement date of the winding up by court is the date of filing of the petition. Date of filing of the petition. After commencement of winding up, any sale, disposition, transfer of any property to be treated as void. The duty of committee of inspection is to inspect and certify the accounts of accounts. Right? 10 marks given here. Number 2, Gamma Limited is a public company duly incorporated under the Companies Act. Right? Recently, due to some reasons, the company is facing serious financial difficulties. Accordingly, last week, the company defaulted to pay Mr. Silva, a creditor of the company. Now, Mr. Silva is seeking the possibility of recovering his money by dissolving the company. Required to outline the steps of compulsory winding up of the company. What are the steps? Outline the steps of compulsory winding up of the company. Number 1, first one is petition along with an evidence. Right. Shall we take that? Right. Petition to be filed along with an affidavit. It's the step. Right. Petition to be filed along with an affidavit. Right. And number 2, court will appoint an official receiver. Court will appoint an official receiver. Number 2. So that's it. Right. Number 3, by virtue of his office, official receiver will be appointed as the provisional liquidator. Provisional liquidator until the winding up order is given. Provisional liquidator until the winding up order is until the winding up order is given. Then number 4, right? The fourth step is winding up order is given. Winding up order is given. Winding up order is given. Okay. Last one is the liquidator is appointed. Liquidator is appointed. Liquidator is appointed. 5 steps. 5 is petition, official receiver, provisional liquidator, winding up order, liquidator is appointed. Advice, Mr. Silva. Yes, what is the advice can be given to Mr. Silva? Now, as a creditor, now he is going to liquidate the company. By dissolving the company, he is going to recover the money. So, in order to, right, as a creditor, in order to make an application to liquidate the company, right, this person, what are the conditions to be fulfilled? Right, if these conditions are fulfilled, then we can make an application for not to liquidate the company. By the petition, so these are the steps we have discussed. By the petition, Mr. Silva can make an application. Right? all the creditors cannot make an application to liquidate the company by court. Like, what are the conditions to be fulfilled? Yes. Yes, three conditions to be fulfilled. Right. Amount shall be more than 50,000 rupees. And written demand. We must, in writing, demand the money. Within 3 weeks' time, we have to give grace period to the company. Right? So within 3 weeks' time, if the company unable to settle the money, and then Mr. Srilanka can make an application to court. Right? So not completely, right? Shall we take your license, right? Number 2, answer to number 2, right? Right? In order to make an application, to liquidate the company by court, by a creditor, following conditions to be satisfied. Right? Number one, the company shall owe, shall owe more than 50,000 rupees. More than 50,000 rupees to the creditor. More than 50,000 rupees to the creditor. Number 2, the creditor shall demand the money in writing. So verbal demand is not creditor in writing. There shall be a letter demand in writing. It is named as LD, letter of demand. So in writing. Then number 3, the third condition, within 3 weeks time, 3 weeks time, the company defaults or neglect to settle the money in full. It be that the company unable to pay its debts. It be that the company unable to pay its debts. Right? The next time we can say, right? Then creditor can make an application. To court to liquidate the company by court. Liquidate the company by court. Right. So these are with regard to the winding up by court. Right. Then right now there are three modes we have discussed. Right. First one is by court. Then thereafter voluntary winding up. This one. Under voluntary winding up, right? You can consider there is small concept we have to learn under voluntary winding up, right? I told you voluntary winding up, it means shareholders voluntary winding up, right? The shareholders, they have given their consent to wind up the company. That is named as voluntary winding up. Right? Or we can pass a special resolution as to company, right, shall be liquidated by voluntary. Right? Then under voluntary winding up, can consider voluntary winding up. Voluntary winding up, we can divide into two, right? There are two types of voluntary winding up. One is shareholders voluntary winding up, right? And the second one is creditors voluntary winding up. There are two types of voluntary winding up. Creditors voluntary winding up, shareholders voluntary winding up, right? It depends on particular document. So this document is named as Declaration of Solvency, right? Very important one. Declaration of Solvency. A document called Declaration. It's actually Declaration of Solvency. Declaration of Solvency. What do you mean by solvency? Yes. Declaration of Solvency. What do you mean by solvency? Solvency and insolvency. Solvency opposite is insolvency. Solvency means now shareholders voluntary winding up or creditors voluntary winding up. Depending on this declaration. This is a declaration given by the means, right? Yes. Right? Solvency means S. Right? Settle. Right? It means able to settle. Able to settle. Able to settle. What? What is able to settle? Debts. Debts of the company. Debts of the company. It means company able to settle its debts. Right? So this is the declaration given by the directors. Right? So actually this declaration, directors of the company, they must declare, right? They have inquired into all the affairs of the company. Right? They have inquired into all the affairs of the company. And the most important part is within 12 months. within 12 months from the date of commencement of winding up, right? They are of the opinion that the company is able to pay all the debts, all the debts. So this declaration to be given by the directors, right? If they are able to give this declaration, right, then it becomes shareholders voluntary binding. If they are unable to give this declaration, it means the company is bankrupt, insolvent, unable to settle its debts within 12 months from the date of commencement of the binding. Unable to settle. It's bankrupt, right? Unable to settle. Therefore, then it becomes creditors voluntary binding, right? So, depend on this declaration of solvency, this declaration, we have to decide whether it is a shareholders voluntary binding or creditors voluntary binding. So, if the declaration is given, then it becomes shareholders voluntary binding. Actually, here what happens, right? The main thing is that shareholders can appoint the liquidator. They will appoint the liquidator. And we will conduct the liquidating process. Shareholders will appoint. The company has sufficient assets. Declaration is given by the directors of the company. The right opinion of the directors will be able to settle all the debts of the company within 12 months from the commencement date of calling, right? Then liquidator will be appointed by the shareholder. So therefore, this is named as shareholders voluntary binding. If the directors are unable to give this declaration of solvency, then it becomes creditors voluntary binding now. Then who will appoint the liquidator? Creditors will appoint the liquidator in order to liquidate the company, right? In order to conduct the liquidating process, creditors will appoint the liquidator, right? They will receive the right to appoint the liquidator. If it is, right, creditors voluntary binding. That is about the right, voluntary binding. Right, depend on the declaration of solvency, we have to decide whether it is a shareholders voluntary binding or creditors voluntary binding. Declaration of solvency. Solvency means settled, able to settle the debts within 12 months from the date of commencement of binding. This declaration to be given by the director of directors, right? By passing the resolution at a director's meeting. So, if it is a shareholders voluntary binding now, they can appoint the liquidator. Okay? Creditors can appoint the liquidator if it is creditors voluntary binding. Then actually we have already discussed about the binding now subject to supervision of the court. That is, the company, right, has decided to liquidate it voluntarily. Creditor or shareholder can make an application to court, right? Court to liquidate the company voluntarily, but subject to supervision of the court. The supervisor will intervene, court will intervene to liquidation. It will monitor the affairs of the company. Court will monitor the affairs of the company. So that is right, treated as liquidation under supervision of the court, by supervision of the court. That's all. That is about the binding of the company. So I think we have discussed many of the topics related to companies act, from the corporation to binding. We have a summary report regarding all these topics. I will upload it to your website. Go to it. You can consider all these details, theoretical parts in the summary. Thereafter, another one topic we have to discuss is those adjacent to corporate law. We discuss some statutory provisions related to companies. like 4.8. Thereafter, we can discuss some the past papers and right, we can finish that. Right. Okay. You can stop for today though. That's enough.